Companies Act, Section 378(o), Composition and Permissible Number of Directors in a Producer Company. Section 378(o) of the Companies Act, 2013 outlines the statutory requirements concerning the number of directors that a producer company must appoint and maintain on its board of directors. This provision plays a critical role in defining the governance framework for producer companies, which are unique corporate entities formed by producers, primarily in the agricultural and allied sectors, to collectively manage their business and operations. This section ensures that the board of a producer company is appropriately sized to allow for effective oversight, diverse representation, and sound decision-making, while also offering flexibility during the initial stages of transformation from a cooperative society to a corporate structure. Statutory requirement for board composition. Under the general mandate of Section 378(o), every producer company shall have a minimum of 5 directors, ensuring that the board is not so small as to lack diversity of opinion or functional capacity. The maximum number of directors shall not exceed 15, thereby preventing overly large boards that could hinder efficient governance and coordination. This range not less than 5 and not more than 15 is designed to strike a balance between representation and efficiency. A board that is too small may lack the range of perspectives necessary for a producer-driven company, while a board that is too large may become unwieldy, slow to act, and less cohesive in decision-making processes. Transitional relaxation for interstate cooperative societies. In recognition of the unique position of interstate cooperative societies that are converted into producer companies, the Act provides an important transitional exception under the proviso to Section 378(o). It states that if a producer company is formed by the conversion of an interstate cooperative society, it may, for a period of 1 year from the date of its incorporation as a producer company, have more than 15 directors on its board. This special provision acknowledges that interstate cooperative societies often have a larger board structure at the time of their transformation, which may include representatives from different regions, sectors, or interest groups across states. Mandating an immediate reduction to 15 directors upon incorporation could result in governance disruption, loss of regional representation, or abrupt termination of directorships that were structured under cooperative norms. Therefore, the law grants a 1-year adjustment period during which the producer company may continue with a larger board. This period allows the company sufficient time to review its governance needs, reorganize its board in compliance with the new corporate requirements, and manage the transition in a structured and inclusive manner without compromising continuity in leadership and representation. Underlying objectives and governance rationale. The governance philosophy behind this section is grounded in the principle that a producer company should function with a well-composed, competent, and representative board that can manage its affairs responsibly. The size limitation ensures efficient decision-making through a manageable number of directors. Accountability and coordination, as larger boards can result in diffusion of responsibility. Adequate representation of the members, particularly in entities formed by small and marginal producers. Alignment with corporate governance norms that promote transparency, participation, and strategic oversight. At the same time, the transitional flexibility for interstate cooperative societies reflects the legislature's intent to support such entities in their transition from a cooperative legal framework to a corporate governance model, without enforcing an abrupt disruption in board structure. Practical implications for producer companies. Upon incorporation or transformation, a producer company must carefully assess and ensure compliance with this provision. In practice, a new producer company, not formed by conversion, must ensure that it appoints not less than 5 and not more than 15 directors at the outset. A producer company formed by the conversion of an interstate cooperative society must prepare to restructure its board within 1 year to bring the number of directors down to 15 or fewer. During the transition year, such a company must ensure that even with a larger board, its decisions, meetings, and governance practices comply with the provisions of the Companies Act and the company's Articles of Association. Failure to comply with this provision beyond the 1-year grace period may lead to regulatory non-compliance, questions of validity in board decisions, or administrative penalties under the Act. For more details, contact us.